Hi, today I'd like to talk about the Appointments Clause of the U.S. Constitution. Recently, a legal expert on cable news has stated that Special Counsel Mueller's appointment was illegal because Mr. Rodney Rosenstein, the Deputy Attorney General, violated the Appointments Clause of the U.S. Constitution when he made the appointment of Mr. Mueller as a special counsel. Could this be true? I think it is true. The appointment of Mr. Mueller violates the U.S. Constitution. The Special Counsel Statute, as being used by Mr. Mueller and Mr. Rosenstein, is unconstitutional. Let's take a look. Article 2, Section 2, Clause 2 of the U.S. Constitution, which is known as the Appointments Clause, governs how federal offices must be selected. It states, "The President shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper, in the President alone, in the courts of law, or in the heads of departments. The Appointments Clause requirements apply only to officers of the United States." Current Supreme Court doctrine defines these officers as appointees who wield significant authority. They are also referred to as principal officers, as opposed to inferior officers. Under current law, courts evaluating whether a particular official is an Article II officer examine factors like 1. The importance of the issues in the official's portfolio. 2. The finality of the official's actions. And 3. The degree of discretion the official has in reaching his or her determinations. Article 2, Section 2 expressly contemplates two categories of government officials. First, there are some government officials of such significance that only the President can appoint them with the advice and consent of the Senate. Second, there is a set of inferior officers whose method of hiring Congress may establish by law. Congress may enact laws that create inferior officer positions, granting appointment authority for those positions to the President alone, the heads of departments, or the courts of law, or leaving in place the default procedure of presidential nomination with Senate advice and consent. The governing Supreme Court case establishing a dividing line between officers and employees, or inferior officers, is Buckley v. Vallejo, which concluded that officers are those government officials who exercise significant authority pursuant to the laws of the United States. The more important the official's task, the importance of the results of the official's task, and the freedom he or she has to do their task determines if he or she is a principal or an inferior official. Mr. Mueller's task is significant enough to be investigating the President of the United States, a very significant task. The results of Mr. Mueller's task could result in the President of the United States being indicted or impeached. Very significant results. It cannot be denied that Mr. Mueller is a principal officer and not an inferior officer. The scope of Mr. Mueller's task is wide. He has significant authority. Therefore, Mr. Mueller's appointment required the advice and consent of the Senate before his appointment could be ratified. This was not done. In this case, the Special Counsel Statute is being used to circumvent the intent of the U.S. Constitution. There is another argument that supports that Mr. Mueller was appointed to a principal position and not an inferior position. A U.S. attorney is appointed by the President of the United States by law, each United States attorney is subject to removal by the President. An assistant United States attorney is an attorney employed by the United States government and working under the supervision of a United States attorney. Mr. Mueller has made sure that 4 of the attorneys working on his team were given titles of Special Assistant U.S. Attorneys. As they are working directly for Mr. Mueller has assumed the authority of a United States attorney. Therefore, Mr. Mueller's appointment can only be considered a principal United States officer and not an inferior officer. Again, the Appointments Clause requires that principal officers be approved by a vote of the U.S. Senate. Mr. Mueller's appointment was not sent to the U.S. Senate for approval by Mr. Rosenstein. The appointment of Mr. Mueller violates the U.S. Constitution. The Special Counsel Statute, as being used by Mr. Mueller and Mr. Rosenstein, is unconstitutional. Well, I hope this helps. Have a good day.